Good afternoon. I'd like to open this meeting of the Oak Island Board of Adjustments, Monday, October 2nd, 2023. The approval of the minutes, first item on the agenda. I'll take a motion for the approval of the minutes or any comments for the minutes.
Approve the minutes.
I'll second that.
Have a motion, a second. All in favor? Minutes are approved. Any old business? No old business. New business. First time in the years I've been on this board, we're going to select a vice chairman. I guess you're thinking at my age I might not show up.
Yeah, I had to call you.
Entertain a motion for someone to serve as vice chairman.
I'll move that we select Mr. Farley.
Have a motion to select Mr. Farley. I have a second. All in favor? It's unanimous. Mr. Farley will be vice chair. Today's business is an application for a variance. And Mr. Eads, are you going to bring that to our
Yes,
table?
sir. Thank you, Mr. Chairman and board members, and welcome to those in the audience. As you just indicated, this is a variance application. It's for the property located at 2512 West Pelican Drive. The applicant is Allied Marine, who I believe is represented here today by Randy Mosley, as well as the property owner, Mr. Richard Aldman. Am I saying that correctly, sir? Okay. Variance applications, and the variance is seeking, they're seeking a variance from the town's bill ordinance regulations, which staff will get into when they make their presentation. A variance hearing is a quasi-judicial proceeding. It's meaning it's just what it sounds like, kind of like a trial or courtroom. We will use the North Carolina Rules of Evidence as a guide, but we will not follow them as strictly as, say, we would in a courtroom. The applicants are entitled to a fair and impartial decision-making body, which means you can't have your mind made up one way or the other until you hear all the evidence, and you have to base your vote solely on the competent material and substantial evidence. So I need to ask, you guys know the routine, I need to ask you a few questions about this particular variance application to make sure there are no biases, overt biases that we need to discuss. Number one, does anyone on the board have a financial interest in the subject matter of this variance application? Okay. Number two, has anyone on the board made a site visit to the site for the purposes of assessing this application?
Like you said earlier, that's not prohibitive, but it's not encouraged.
Right. You have?
I did, just to more clearly understand the conditions of the site.
Okay. Was there anything about your site visit that would prohibit you from basing your vote today solely on the competent, substantial, material evidence presented during this hearing?
Oh, and I will note that I didn't speak to anybody while I was there.
Okay. Mr. Allman or Mr. Mosley, do you have any questions regarding the site visit?
No, just the one gentleman went?
Yes, sir. Okay. And I note in the agenda packet, there's pictures as well.
Yeah.
So, okay.
Mr.
All
Eads,
right.
I think two other members raised their hands.
Oh, did they?
Chairman Simmons and
Oh,
Mr.
I didn't see
Farley.
that. Okay, Mr. Simmons, Chairman. Anything about your visit to the site that would prevent you from being fair and impartial and base your vote solely on the competent evidence?
No, I don't believe so.
Okay. Anybody else? Any questions regarding? Okay. Madam Clerk, let the record reflect that the applicants and Mr. Mosley have no questions to the board members that have volunteered the fact that they have gone to the site. Next question is conversations outside of this hearing. They're called ex parte conversations. Has anyone had any discussions with staff about the subject matter of this variance application? Okay. Has anyone had any discussions with the applicants or the homeowner about the subject matter of this variance application? All right. Next question is, does anyone on the board have a either close personal business or family relationship with either Mr. Mosley or the property owners, Dolmans?
I was a treasurer of an HOA that we utilized his services probably 6 or 7 years ago. No interaction on my part other than approving the estimate, inspecting the work, and approving the issuance of a check. Everything was handled by the management company, including the selection of his company.
You personally didn't have any discussions with Mr. Mosley or anything like that?
Don't know him at all.
Okay. Anything about that experience that gives you concern about, as to whether you can be fair and impartial?
No.
Okay. All right. Can any of you think of any reason, whether I've asked you or not, why you can't be fair and impartial and base your vote today solely on the competent material and substantial evidence that we hear during this hearing? All right. Being a quasi-judicial hearing, all witnesses who wish to provide testimony, including staff, shall be first sworn in and subject to cross-examination. The applicants have the burden of proof to show that they have met the 4 criteria that can be found on page 6 of the agenda packet. It requires a 4/5 vote to be granted, which means not a simple majority. It means 4 of the 5 members have to vote in favor of granting the variance. Again, the applicant has the burden of proof to prove through the evidence they offer that they are entitled to entitled to a variance. The way we'll proceed is, first, we will have Mr. Brady Golden, Town Planner 1, introduce the item on behalf of staff. He'll be subject to cross-examination and subject to questions from the board. We will then hear from the applicant and their witnesses. They likewise will be subject to cross-examination and questions from the board. And then any other party that has standing that wishes to testify either in favor or against this variance, we will hear from them lastly. If there are opposing parties, we will give the applicant the opportunity for a rebuttal since they have the burden of proof, just like we would in a court proceeding. That's kind of the layout, the ground rules. Do you have any questions? Any members of the board have any questions?
Anybody have a question for that?
Yeah, I have a
Go ahead.
question just for my own understanding. The variance request, is it for a variance to the specific requirements of the permit, or is it a request for a variance from the requirement for a permit?
I don't want to speak on behalf of the applicant. I've read their application, and perhaps before we begin, kind of take it out of order if either the staff or the applicant wants to answer that question.
I need to administer the oaths first. Yeah.
Oath first is what she's.
Yeah, do I need to administer the oaths first?
Not
No?
I mean, you
Okay.
can or can't, it doesn't matter. I think that's we need to know why we're here and what they're seeking.
Then I need him to come to the podium.
Right. Can you clarify, Mr. Mosley, or Mr. Holman? Could you come up to the podium and just identify yourself?
And state your name and address, if you will.
Own Allied Marine Contract.
Do that at the microphone, if you will.
Yes, sir. Randy Mosley, I'm half owner of Allied Marine Contractors. I think the reason I asked for a variance was because I felt like I would have better luck with that than saying the field permit should have not been required, which is what I believe in my heart. Does that answer the question?
Not specifically, but maybe that will answer, maybe will be fleshed out a little bit more as we hear testimony. I think that may be the best that we can do at this point.
And as we hear the evidence, we can flesh that out more. Yes, sir. All those who wish to provide testimony or think you might provide testimony today, if you would, please stand and be sworn. Ms. Stipes, do you want them to come over to you?
Then left hand on the Bible and raise your right. solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
All right, if we're ready to proceed, we'll hear from Mr. Golden.
Questioning his decision, but we should have it.
All right, my name's Brady Golden. I'm the planner one for the town of Oak Island. And we're going to hear from about the application for the variance to the fill ordinance at 2512 West Pelican. So first, we're going to understand what the variance standards are. General Statute 160D 705D kind of explains out the variance. It's when unnecessary hardships could result from carrying out the strict letter of a zoning regulation. The Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all the following. Number one is an unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that. In the absence of the variance, no reasonable use can be made of the property. Number two, the hardship results from conditions that are particular to the property, such as location, size, and topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Number three, the hardship does not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And number four, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such the public safety is secured and substantial justice is achieved. And the variance requires a concurring vote of 4/5 from the board in the affirmative. A little background, subject property is located at 2512 West Pelican Drive, tax parcel ID 234JA008. It is in the R7 residential zoning district, and the applicant has requested a variance to the fill ordinance requirements. Below is what the ordinance says on fill. The amount of fill added to a lot will be no greater than 1 foot above the crown of the road, or even with the highest adjacent lot, whichever is less, and will not be greater than is necessary to meet the health department requirements for an improvement permit. Fill greater than 1 foot will have an engineered plan for stabilization and stormwater retention, and lots requiring fill greater than 1 foot for the purpose of elevating above flood for a letter of map revision based on fill, leveling a lot with drastic elevations, or for the purpose of commercial stormwater design may do so in accordance with section 10.104.1. Here's a vicinity map showing the location of the property on West Pelican and butts up to the Montgomery Slough, so indicated by the red dot in the center of the page. Here's a zoning map showing that it is surrounded by other parcels in the R7 residential district, also indicated by the red dot in the middle of the page. Here's a timeline of the events. A CAMA permit was issued by Patrick Amico, a DCM field rep, for a proposal to construct a private docking facility with 2 slips and a bulkhead landward of coastal wetlands with 2 return walls. An accessory structure building permit application was received on June 19th and issued on June the 22nd of 2023. On July 12th, a complaint was received from a neighboring property owner with concerns about excessive fill dirt. After an investigation, a code case was opened for work without a fill permit on the same day. The applicant was notified of the violation, and a fill permit application was turned in on July the 17th. Upon review of the fill permit application, supporting documents were found to be not consistent with the fill regulations and was denied by planning staff. The applicant is seeking a variance to the standard found on the attached site plan. Here's a site plan that was attached into the fill permit that was submitted, showing the area that was to be filled. Here's a diagram of a cross-section of the lot that was going to be filled. And let me know if you need me to go back for any clarifications or other review of these documents. Here are some site pictures taken 2 weeks ago. On the left is the left side of the property looking north. On the right is the right side of the property looking north. Here are the back left and right corners of the property showing the fill to the retaining wall, also looking north. And once again, here are the standards for any questions or clarification. That's all I have. If you have any questions, I'm happy to answer.
Mr. Chairman, if I may,
Yes,
as a matter of housekeeping, it appears pages 5 through 61 of the agenda packet are the materials associated with this variance. Would you like to offer that into evidence as Exhibit 1?
Yes.
Any objections, Mr. Mosley, Mr. Alm? Chairman, I recommend we receive pages 5 through 61 of the agenda packet into evidence as Exhibit 1 without objection. Chairman.
yes, okay, fine.
Brady, excuse me, Mr. Golden, if you'll turn to page 27 of the agenda packet. And after you get there, let me know.
Yes, sir.
Now, if you go back in one of your earlier slides with the timeline. One more, okay. And the second bullet point reads an accessory structure building permit dated 6/19/23.
Yes.
Oh, excuse me, received on 6/19 and issued on 6/22/23. Is the permit depicted on page 27 of the agenda packet that permit?
Correct.
And who fills the project description out?
That is the ladies in the permitting office. They
Town employees? Because I'm just making sure, on the second bullet point, I see accessory structure building permit, but the project is entitled dock, bulkhead, roof, flooding dock, and lift, or floating dock. My copy's not that.
Right. Yes, sir.
Floating dock and lift. Is that right?
Yes, sir. We for permits like those, they are put in as accessory
Okay,
structures.
well, it wasn't clear to me, and I didn't know if the board members had any, the same type of question after reading that bullet point number 2. So I just wanted to make sure we're talking about the same permit.
Yes, sir.
Okay. All right.
I have a question about that, if I might. Is it possible in Oak Island to have an accessory structure on a lot without having the principal structure associated with it?
Only for these types of developments that are water dependent and like docks and require CAMA permits.
Okay. So it is possible to put the dock on there and then have nothing else on the lot for the foreseeable future?
Sure.
Okay, thank you.
Anyone have any cross-examination questions of Mr. Golden at this time? I didn't see who all was sworn in. Was there a third? Can you explain? Sir, if you'll come up,
He was not sworn in, Mr. Eads. So if he wants to question, okay, that's fine.
get sworn in first, if you don't mind.
And then I'm sorry to be so difficult, but I do need it on the record, so I need to go to the left hand on the Bible. Raise your right. Do you solemnly swear that the evidence you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
You come to the lectern and ask whatever questions you'd like, sir.
State your name and address, if you will, please.
Richard Allman. I'm property owner, 2512 West Pelican, and I have a house at 2518 West Pelican. I was just asking, when you had a question about the permit and you were going over the permitting about the walls and all that, I mean, what does that include? I mean, so I'll understand where I'm at and what's going on.
Golden, you want to answer that question?
Sure, and I may need some assistance from Courtney, our CAMA LPO, but I believe that this, the process is the CAMA permit is applied for first. And the fill is a development permit, so you're not technically developing the property first. You've got the CAMA permit for the associated water-dependent structures, and then the building permit comes in for those structures for inspection. If the property were to be, a house to put on the property, that's when you would need a fill permit if you want to put fill, or if you were going to want to put a structure on it, actually developing the property.
Excuse me, if you want to discuss anything, do it on the record if you will at the podium.
Folks, there's a reason for that. Madam Clerk's taking minutes, and if we need to see what happened at this hearing later, it's much easier for her to get it down if someone's speaking from the lectern.
Speak my name again, or?
No, you're
sorry.
fine. You're fine.
I guess my question is I'm trying to understand the difference when you're putting a seawall in, and you do that first before you would really, well, you wouldn't do it first, but on this particular instance, we're not to build a house yet, but to put the wall in, you gotta, that's what I want to understand is where the difference comes, what you're saying. I guess I'm hearing you say for development or whatever, but still, you're putting a seawall in, correct? I want to understand the difference. That's what he's saying.
The land development permit is not required for a seawall or a dock or any water-dependent structure. When the development of the property is for a permitted primary use, which is a residential structure, that's when the development permit is supposed to be filled out and applied for, not at this point. I understand. Yes, sir.
Any other questions for Mr. Golden?
I've got a question. I'm trying to figure out what exactly is the violation here?
So the fill was added without being properly
Permitted, I get
permitted,
that.
right.
But is it more than a foot above the street?
So we do not have the appropriate documentation to evaluate that. Anything more than a foot of fill dirt added has to have professionally designed cross sections. We're supposed to have pre-elevations and post-elevations, and we could never receive the pre-elevations because the fill dirt was added before it could be evaluated.
Okay. So then I have a question, kind of a follow-up question on that. The CAMA permit allows the construction of a bulkhead. And apparently this permit also allowed the construction of the return walls. But the CAMA permit doesn't allow filling behind those walls once they're constructed?
Were you sworn in, Matt?
I was.
Identify yourself.
Matthew Kirkland, I'm the planning director for the town of Oak Island. The CAMA permit doesn't necessarily permit the construction of something in town property. You also have to get the associated development, accessory structure permits, and Courtney can probably chime in on this too, but you don't just need a CAMA permit to build something in a CAMA development regulation.
But in this case, he got the CAMA permit, and then he got a development permit for constructing the bulkhead itself.
You got an accessory structure permit.
Right, for constructing the bulkhead.
Correct.
But what I think I'm hearing you say is that you he got the appropriate CAMA permit and the appropriate development permit to construct the bulkhead.
You got the appropriate building permit to construct the bulkhead, yes, sir.
But what you're suggesting is that once that bulkhead was constructed, he needed to come back and get another permit in order to fill behind the bulkhead.
Correct. He needs a development permit for the fill. That's correct.
For the fill behind the bulkhead.
Yes, sir.
Regardless of
Yes, sir.
how, if the bulkhead had only been 8 inches, then he wouldn't have needed a permit. Is this what I'm to understand?
No, if you're going to add any fill to the lot, we need a fill permit. Yes, sir. That's correct. The standards for fill are not just that at a certain amount you need something. The fill is to 1 foot over the crown of the road or the highest adjacent lot, whichever is less So if your highest adjacent lot is less than a foot over the crown of the road, you can't go to that foot over the crown of the road, you go to the highest adjacent lot. So anytime you add fill to a lot, we need to see, as Mr. Golden mentioned, that pre-elevation and your proposed post, so we know whether or not you meet those standards. If you do if in coming to that elevation, you add more than a foot of fill, then you need a further step, you need an engineered stormwater and soil erosion retention plan to be reviewed by the stormwater administrator. Yes, sir.
You can't construct the bulkhead without installing the dead man, and that requires fill to put in the bulkhead.
We've actually had folks install retaining walls with dead men that are exposed that are not backfilled. We've ran into that recently, actually. So,
But I thought it required fill over the dead man so that the security of the wall was.
according to our, well, he's not here, I can't really speak, that'd be hearsay, I suppose. According to Steve Edwards, our chief building official, it is not required to backfill over the dead men if they're installed appropriately.
Well, what I know about construction, it wouldn't be a solid wall till the dead man is put in, inspected, covered up. And that's what helps it to stay in place.
I'm
A
only giving you,
bulkhead with an exposed dead man might be for permitting processes, but it wouldn't be a secure bulkhead.
I'm only relaying the information that I got from our chief building official for the town of Oak Island.
It would not be secure.
Any other questions for staff?
I have one question. The stop work order was done by a zoning technician. Is he here today? Steve is his boss, right? Now, I'm just noting David Emerson's mentioned in here, and he's not present to give testimony, that's all.
Correct. I'm sure he's out in the field currently.
He was probably sent to post the stop work order. I doubt he was determined that it needed one.
Okay, yeah, good point, Bruce.
And I'll point out that if there was an appeal of the stop work order being done,
As in a question of administrative decision.
that's right.
Which
In which case, Mr.
he wasn't aware he could do.
In which case, Mr. Emerson would be here to.
Absolutely,
Yes,
thank
sir.
you for
You're welcome.
answering that.
Which being an appeal of the decision, not the variance.
That's right.
Any other questions?
Mr. Mosley or Mr. Alman, do you have any cross-examination questions of Mr. Kirkland based on what he just testified to?
Are you going to be the only one speaking for the town?
Sure. Yes.
Okay. I was going to comment that the chain of events, a reputable, experienced, knowledgeable bulkhead builder with many projects under his belt goes to pull a permit to build yet another bulkhead in the town that he's built many in. The inspections department sees the location, the plan for the bulkhead. They put the retaining wall in, the dead men, the cabling, and then they send an inspector out there to look at the dead men, the cabling, the height of the bulkhead itself, knowing good and well, it's got to be filled like any other bulkhead, and let it go on. Looks like you're leading a blind man across the street, ready to get run over. It doesn't sit well with me. Somebody should say, "Wait a minute now, you're getting a little out of bounds there." Let me read you the exact wording of the fill ordinance that we have before you get yourself in over your head. That never happened.
So the permit that was applied for was the building permit, and there was the fill, although based on whatever the general practice of bulkhead building is, the building inspectors aren't tasked with, you know, UDO ordinances. That's with zoning, so that's why it wasn't picked up when they were doing inspections for the wall. They were inspecting it based on the building code, not the UDO regulations.
Yeah.
Do you need, I'm gonna ask this for later reference, does the town need to inform people applying for a bulkhead that, no, you gotta get a field permit at the same time, or you can't put in the bulkhead?
The bulkhead can be independent from the fill. If they are planning on filling, that's in our development permit. The fill ordinance is within the development permit, but not with the building permit.
I think that question has merit. It's kind of beyond the scope of this hearing, and that's something that staff would have to look at and determine whether a proposed text amendment to address that question. But we're here today based on the variance applications. Point noted. Any other questions of Mr. Golden?
I had one more. When the level, when they got done, I read in here somewhere they were exactly even with the adjoining property. Is that correct?
We have no documentation to see if that's correct or not.
And I don't have any information.
I mean, it comes to the matter of field, is anybody here that can tell us when they got through, was it even with the adjoining properties? Anybody here that, Mr. Eads, if you guys could testify?
I believe, and it's already in the evidence as Exhibit 1, I believe some of the information submitted by and I don't want to speak for the applicant or Mr. Mosley. I believe there's an assertion in here that addresses that exact question, so maybe Mr. Mosley can address that, or Mr. Allman when they come up.
Thank you.
Yes, sir. Thank you.
All right, Mr. Allman, it's your property. Is it your turn to put on?
I'm sorry, I thought Mr. Kirkland was going to come up and speak. I did have a question for, and maybe, what would it take for this applicant to come into compliance with the ordinance at this time?
Sure. So when we have Phil, and actually Brady would be in good form for this because he actually reviews these permits, you would need a pre-elevation showing the lot elevations before Phil, as well as some adjacent lot elevations as well, because we evaluate it based on the highest adjacent lot, right? So we need to not just know the elevation on your lot, we need to know the elevation on the adjoining property boundary lines as well. Then we need to see a post elevation for what fill you're proposing, and we need to be able to match those up with the highest adjacent, to even with the highest adjacent grade, or 1 foot over the crown of the road, whichever is less.
So then I'm to understand that basically he would have to remove all of the existing fill to take it back to natural ground in order to determine what.
We at least need some type of data to show the fill elevations. Whether he'd have to remove it or not to get that out, that's a question for a surveyor. I couldn't really speak to whether or not somebody could pull data to show the existing fill before or the existing elevation before the fill was put in.
Thank you.
You're welcome.
Mr. Mosen? And I know you've already identified yourself once, but we weren't on the record at that point. You hadn't been sworn in, so if you'd just identify yourself.
I am Randy Mosley, Allied Marine Contractors. We're a local firm. I've been doing this type of work on the island for over 20 years. Longer than that in the eastern North Carolina area, but I've been on the island about 20 years. Been doing bulkheads during that whole time. I've built a lot of them on the island. This is the first time I've ever been requested or heard about a fill permit on any bulkhead I've ever built. I've asked other guys that I know that built bulkheads for a long time. They're not familiar with getting a fill permit. You get your bed men inspected, you fill the bulkhead. That's just always how we've done it. If we need to do it different going forward, you know, we can do that. But I don't, this whole thing's crazy.
I have just one question, if I may ask you, and I read it in here somewhere, but I wanted confirmation. The elevation of the field now, is it level with the
Yes, sir.
adjoining lot?
So there's two lots, right? The one to the east already had a wall. So we built our wall exactly to that level and followed that level around where Kama said I could put the bulkhead in. So it is exactly the same level as the bulkhead to the
And
east.
that is less than the crown of the road?
Oh, yes, sir, by many feet. So I'd say 5 feet.
That's all I have.
I will say, I built another bulkhead during the same period and probably brought in 2/3 that amount of fill on it. No issue.
Is there anything unusual about this bulkhead that would?
Well, it does have that one long wing wall on the east side, because, you know, just because the shape of the marsh comes, you know, they're kind of a little, and it's not really a peninsula because it's same over here, but then it dives in a little cove over here beside this one. Okay. So you have that long wing wall, but he's got high ground there. He's well within his rights to have that wall. And like I said, we just did standard practice. You try and match the grade with the surrounding walls so everything's the same level.
Right, so, and I don't, just try to understand, the base of the bulkhead on that faces out to the water.
Yes, sir.
The base of that, where does the base of that sit relative to the original slope of the lot?
It's, well, the lot was kind of like this, falling to the east. It's about 2 feet on the west corner tall, maybe 2.5-ish, and probably 5.5 to 6 on the, east corner.
Okay.
Yep.
I mean.
And then it comes back, you know, that wing wall comes back to about, I don't know, 4 feet to match their grade.
But the base of the wall, is it basically where the water came to?
It's just behind the we knew there was, going into this, we knew there was going to be some neighbor issues. So I made sure Kama knew. So we had the Corps come out and delineate the high tide line and make sure everything was, especially going up that side, that we weren't getting in any wetlands.
Okay.
And then we actually stepped back from that because Richard, the way that sticks out, he's got a nice backyard there.
Thank you.
That was a question I was going to ask. Even during a king tide, does any of the wall get wet?
Sure. Yeah, it gets up on it on a king. Yeah, it's been on it this week. I hadn't been down there this week, but I can tell you that water's been up on that wall this week. You know, the water hits the walls there's walls to the east of it. The 3 lots to the east of it are bulkheaded in the same manner. They were filled in the same manner, and I'll bet you $1,000 there's not a fill permit on them.
Any further questions of Mr. Mose?
None for me.
Yep.
I just want to clarify, do you have an agenda packet up there, sir?
Yes, sir.
Can you turn to page 19?
I'm finding numbers.
The
I
actual-
got it.
That appears to be an email from you to David Emerson.
Yes.
Okay. And then you state in the email, and I'm just going to summarize it, we all have it in front of us. Never been asked to get a fill permit when backfilling the bulkhead. It's always just part of the bulkhead permit.
That's the way it's been as long as I've been building.
And then when you reference the bulkhead permit, you're referencing what we
Just right here.
discussed
From
earlier.
CAMA. And then, well, that's the building permit. This is
Right.
the actual one from CAMA, yeah.
And the project description for the accessory building permit has dock, bulkhead, roof.
Yeah, if
floating
we can
dock.
get the stop order stopped, we'll build that, yeah.
That's all the questions I had. Any other questions from the board?
And I'm sure going forward, there'll be fill permits on bulkheads. I know this, where this is landing, you know, but I'm telling you, in the past, I've never had to deal with that. Never even heard of it until Mr. Brady came and saw me that Friday and hung his red slip up.
How strong is the bulkhead if you don't put the dead man in?
I mean, that doesn't even make sense. That's a silly question. That's what holds the wall. And the field, but
And
yeah.
the field that goes on the dead man.
That's just how we've always built them. I've got a lot of illegal bulkheads out there.
From your experience, I just can't see how you build a bulkhead without the dead man, and it still is no strength to it until you backfill the dead man.
It's always been understood. I've never, like I said, you had a complaint here, and it turned into this.
Well, Mr. Mosley, and I think someone's already asked you this question, but it's your testimony that the elevation, and you heard Mr. Kirkland say what he needed.
It matches the exact elevation of the bulkhead to the east.
Okay. Any questions from the board?
Well, I do have a question of staff, though.
Okay. Let's let staff cross-examine Mr. Mosley.
I'm gonna get the pointer here. The elevation that you say you match. is-
Right there in that corner, yes, sir.
So
Yep,
you match this elevation.
Yep.
Spot elevation right here.
yep,
And you've constructed this wall.
flat.
This wall and
Yep.
this wall. Do you match, which lot is higher? Would you say?
That
Which lot elevation of the two is the higher of the two?
well, where are we taking it from?
That's, my question is,
It says the highest adjacent lot. It doesn't say where you take that from, so if you go up there on the highest lot, it's up there under those houses, and it'd be under that one, and it's probably 3 feet above the crown of the road under that house.
Okay, so are you?
Or 2 feet.
Higher than this lot in this area to the rear?
That's
The rear of
wetlands.
the bulkhead, but are you higher?
I'm higher than those wetlands, absolutely.
Higher in this lot?
That's kind of the point of a bulkhead.
I'm just asking the question.
Yes,
Are you
I'm higher.
than the lot?
Yeah, that falls back into grade there on that side, yes, sir.
Okay, so just for this board's information, the way town staff reviews elevation of the highest adjacent lot, we don't take one spot. We review the contour of that highest elevated lot.
I would suggest to you that's not what the ordinance says.
That's an interpretation issue which is not in front of this board.
All right.
You're here to determine whether or not a variance should be granted based on the standards in the state statute.
Anything further, Mr. Mosley?
Unless anybody's got any questions.
All right. Does the applicant wish to put on any additional evidence at this time?
It's all spelled out in that packet pretty good.
Okay. Thank you, sir.
Yes, sir.
Madam Clerk, anyone else get sworn in that hasn't testified?
Actually, I would like to add one thing.
Yes, sir.
So you've got the lot in question and the one beside it that I matched the bulkhead to. And you go over, these 2 lots are bulkheaded. They match that grade here and run out 25 or 30 feet, come over and die back into grade on that side where there's no bulkhead on that end. It's the exact same thing.
Thank you, sir. Madam Clerk? All right, Mr. Chairman, it appears that all the witnesses that wanted to testify have testified. The witnesses have been subject to both cross-examination and questions from the board, and I asked a few. Let's suspend the evidentiary hearing, and I used to close them, but I say suspend in case you have questions as you deliberate.
I did have a question of staff.
Okay. Who would you like to ask?
and I know I shouldn't ask a question that I don't know the answer to.
It's a little different when you're the fact finder, though.
But over the last year, say, of all the bulkhead permits, building permits that you've issued, what percentage of those have you subsequently issued fill permits for?
I'd hate to give you an off-the-cuff, top-of-the-head answer. We'd have to pull that information from the databases that we have available to us. But I can say from experience that this is not the first time where we've had either a bulkhead or a retaining wall put in, fill put in afterward, and we've had to ask them to come into compliance with the fill ordinance where they had not before.
Oh, and to follow up, what has been the general procedure for doing that?
As I mentioned, we notice a violation. We ask them to turn in a fill permit application. We review the information in that. If we need additional information to determine whether you're compliant with the ordinance or not, we ask for that. And then we either approve or deny the permit based on your, for the fill, based on whether or not your compliance with the zoning ordinance.
Thank you.
You're welcome.
All right. Can suspend the evidentiary portion of the hearing and
Yes.
begin
Go
deliberation.
that route. We'll close this portion and go into deliberation. I got a theory, if you're interested in hearing it. We got a lot of ordinances, rules, regulations, laws and such in town. A lot of times we skirt them because they're sometimes not that serious. But if a citizen complains about one to the police, the fire department, building inspections, whatever, if a complaint is filed, they've got to follow up on it. And if a violation is present, they have to act on it. And sometimes that occurs. And it looks like this is one of those cases where somebody just kind of raised a red flag and caused a hornet's nest. I don't think we started World War III here, but it did cause a lot of trouble, a lot of. I think we're going to find hardship on some folks, especially the homeowner in this case. And I think it could have been avoided early on if somebody had mentioned this before it got this far. Anybody else have any comments on this?
I think if the way it's presented today by town staff, they need to inform anybody else building a bulkhead, because you don't build a bulkhead till you're ready to fill the backfill. And I guess it was checked, and I really believe if there hadn't have been a complaint, we wouldn't be here today. It would be a very unnecessary hardship to dig it up to prove the elevation before. I just think that's out of line.
Now, if you read further into the
Unnecessary hardship.
in what digging it up and verifying the elevation differential. There's more to it than just seeing if it doesn't meet that 1 foot, there's a lot more to it. Gets real complicated after that, real expensive after that.
Yeah, it'd be unnecessary, and I think there's a general agreement that the elevation is consistent with the adjoining property. So.
I don't believe that. I know Mr. Kirkland asked some questions, but I don't believe Mr. Mosley's testimony to that effect was disputed or contradicted. I think you asked some clarifying questions. So I think for purposes of today's hearing, and do you agree with my assessment, Mr. Kirkland? Because I don't want to put words in your mouth. So Mr. Mosley's testimony in that regard is essentially uncontradicted, that it's compliant, whether it be the adjacent property or the Crown.
Now, the essence of it, I think, is not that it's out of compliance, is that a permit wasn't applied for. It might be in compliance, but the permit wasn't applied for, and that's the issue right here. And if they apply for a permit, before they can apply for a permit, they got to meet these certain criteria, and that's get the elevations from a surveyor justified. And I don't think we're here to dispute the elevation differences between the lots right now. It's just the issue of they didn't get a permit, and they're being held accountable for that unless they can get a variance away from that particular permit in this case. And that's what we're looking at.
I applied for it, they denied it.
Go sit, if anybody's gonna speak, get to the podium.
I applied for the field permit after the fact.
I think you
They
missed
didn't like
that.
my drawings and they denied it.
You were saying?
I applied for the field permit after the fact, when all this came into being. I had it turned in, they told me Friday, I turned it in Monday. 3 weeks later, they told me I wasn't in compliance. After I asked.
All right. So,
Where are we at, Mr. Eads, as far as we got away from our
if
hearing?
I could ask some
Can I
questions.
answer the chair's question real quick? You know, like I said earlier, we were just gonna pause, if you will, the evidentiary hearing for
All right,
purposes
we can
like
go back
this.
in it for a little bit.
Yeah, so we're in it now because he
Okay.
just gave testimony. Go ahead, sir.
So, there was a permit applied for and denied. And there are specific criteria by which the permit could be approved.
Yep.
So what we need is a list of those specific criteria to see if we could give variances to those criteria that would then allow the permit to be approved.
And that's what I asked, that's what my variance was for whatever portion of field they're telling me I'm up and over their line.
So
That's too complicated.
Right.
it
We
is
can just grant variance or not, without having to go through all the individual criteria. I mean, I understand what he's saying. You needed a pre and a post elevation, and you need a licensed engineer to sign off on it, or a surveyor, or something like that. But
We're back into
the dirt's already
deliberations again.
there.
Yeah, we passed that point.
Okay, I'm just looking for something that would
Yes.
carry a little bit more weight, would it?
Well, yeah, I mean, I think a variance from either one, the requirement of a permit, I mean, that's what a variance for, is to vary from the requirements of the ordinance, or a variance that based on these facts and circumstances, that the permit should have been issued, either way. And I'll just note too, well, I'll let y'all continue to deliberate.
Well, if that's the direction that we're gonna go in, then I would suggest that we look through the criteria with an eye to granting a variance.
Yep.
All right.
That's it.
If I offer up the last three dashed bullets on this slide are the criteria for Phil to be compliant with the ordinance. So if that's helpful at all.
So if you want to go that route, you would have to vary from the second 2 points.
Now, this is what I was getting, at a while ago. If you start digging too deep, excuse the pun, you could open up a can of worms that now we're getting into stormwater issues, engineering issues, no telling where it's going to end as far as cost,
I'm thinking
hardship.
just simply unnecessary hardship would result from the strict application of the regulation in this case, and that covers it.
I would agree with Mr. Thomas on that.
So would I.
Well, don't we need to find all, that it meets all four criteria?
Yeah, but we're just doing that one.
Yes.
Yeah,
Okay.
and I say all four.
But we'd take them one at a time, take a consensus.
There you go. There you go, Ray.
Let me get the next one up there. You'd think I'd know this by now, wouldn't you?
Yep.
The hardship results from conditions that are peculiar to the property, such as location, size, topography. Obviously, if it needed to be a bulkhead and backfill, that is peculiar to that property. So I would say that strikes that one as a yes. It may be granted necessary to make reasonable accommodation under the Federal Housing Act for persons of disability or hardship did not result from actions taken by the applicant or the property owner. No, that's the way the property was when God created it, so it wasn't their fault. The requested variance is consistent with the spirit, purpose, and intent of the regulations, such as the public safety and security of substantial justice is achieved. And again, that relates to the use of personal property, and I've always been an advocate of personal property use, and as long as you stay within a reasonable restriction of the law and such. But I think that met that fourth one too. So I'm saying it met all four too.
Would you like to take?
What do y'all think?
I agree.
I would agree also, Mr. Chairman.
Then I'll entertain a motion and not step outside my bounds.
I'll move that we grant the variance.
I second it.
I have a second. All in favor? And it's unanimous. Mr. Mosley, you have your variance.
Get the fill permit, Mr.
You like
Is there any other business before the board?
And it's gavel time.
No staff member report, so
Just a suggestion that possibly in the situation, in the case of bulkheads, maybe a little bit better coordination between planning and inspections, or zoning and inspections might be in order.
Yeah, that'd be up to that department.
Can I still make a statement? Just regarding that, that'd be the end of bulkheads unless they figure those rules out.
Entertain a motion.
Hit the gavel,
We
Chairman.
got John.
Adjourn.
Unanimous. Thank you, folks, for coming.
Yeah.